Good morning everyone, and welcome to the 31st meeting of the Education and Skills Committee in 2019. I remind everyone present to turn mobile phones and other devices to silent for the duration of the meeting. The next item of business is a decision on whether to take future consideration of the draft report on Disclosure Scotland Bill in private, and members can to do this. Thank you. Our next item of business is the fifth and final evidence session on the Disclosure Scotland Bill. We've heard from a range of bodies since September, and all of the evidence we have received has been very helpful. And today we are welcome to the committee the Minister for Children and Young People and her officials. Good morning to Marie Todd, MSP, Minister for Children and Young People, Scottish Government; Kevin Lee, Disclosure Bill Team Scotland, Disclosure Scotland; Gerard Hart, Director of Protection Services and Policy, Disclosure Scotland; and Gemma Grant, Lawyer, Legal Director of the Scottish Government. And can I invite the Minister to make some opening remarks?
Good morning, Convener, and thank you for inviting me to give evidence on the general principles of this bill. The Disclosure Bill is the result of extensive engagement both through the day-to-day operation of Disclosure Scotland and the specific review of disclosure since 2016. The PVG scheme is widely viewed as a vital tool to support safe recruitment and public confidence in those carrying out certain roles with vulnerable groups. Recent inquiries involving sexual abuse in sport and other spheres of life that impact children have once again raised public consciousness about the importance of safeguarding. There have also been a number of high-profile cases involving the exploitation of adults, which have served to remind us that the PVG scheme exists to protect us all in circumstances where we may become especially vulnerable to harm. However, it is clear that change is required to ensure that it remains able to meet tomorrow's demands. Since becoming Minister for Children and Young People, I've heard moving accounts about the ongoing impact of disclosure for children and young people who have come into contact with the justice system. It is with this in mind that the bill makes new provisions surrounding the disclosure of childhood offending and seeks to simplify the process for adults to realise their right to apply for removal of certain disclosure information. There's been a focus in committee on fees, on the decision-making frameworks underpinning disclosable information, and a minimum age on accessing disclosure. I acknowledge that these are areas that stakeholders would like more information on. I understand the concerns from individuals and organisations alike on the impact of changes to fees. Though the proposals within the bill can be delivered using the current fee structure, there is a question of whether we can find better ways forward. I have an open mind towards the issue, and I'm committed to consulting fully on fee structures. However, I want to be clear that the fee waiver will continue for qualifying voluntary organisations. I'm also committed to the statutory guidance surrounding the review processes being developed in consultation with stakeholders. Comprehensive and clear guidance will accompany these changes to the disclosure system. Our stakeholders have committed to help us to draft this guidance and to test it with their users and to ensure it meets their needs. I understand the concern that an unintended consequence of setting a minimum age for disclosure may be that organisations avoid taking on volunteers at this age. In England, Wales and Northern Ireland, children under 16 cannot obtain state disclosures. This has not impacted the many UK-wide organisations who offer opportunities to children. I will ensure that Disclosure Scotland and the wider government communicate effectively in this area to make sure that children are not disadvantaged in gaining volunteering opportunities. I'd like to thank everyone who has provided evidence to the committee. We've listened carefully, and we will continue to proactively engage with stakeholders to strengthen and to improve the bill. I'm happy to answer questions and to provide more detail as the bill progresses.
Thank you very much, Minister. I'll move straight to questions and can invite Liz Smith.
Thank you. Minister, this bill's been generally very well received in terms of its basic principles and certainly the intention to simplify quite a number of issues. I think you yourself cited the fact that with regard to the existing circumstances, it's not always the case. So with that in mind, I think the issue that we need to consider is some of the complexities that the witnesses from whom we've heard recently have flagged up to us. Could I start just by asking you about a sentence that is contained within the letter from the Faculty of Advocates to you, where it's saying that and I quote, "The proportionality of the disclosure will inevitably require balancing the rights of individuals with the potential risk to members of society." In other words, the balancing act is of the greatest public importance. I think all the witnesses we've heard agree with that. Minister, how confident are you that there is a good legal foundation to that statement?
So I am very confident that there is a good legal basis to that statement. As I explained in my letter on the 21st of October to the committee, the two-part test of being relevant for the purpose of disclosure and ought to be included in the disclosure is well established in the context of decisions by the police to provide ORI, for example, for inclusion in a disclosure certificate, and it's been approved by multiple decisions of the UK Supreme Court. We need to be very clear about what type of information we're talking about, to which the two-stage test applies. The two-part test of whether something's relevant to the purpose of the disclosure and ought to be included in the disclosure applies to three separate categories of information: ORI, childhood conviction information, and removable convictions. And although the wording is the same, these tests will be applied in different contexts depending on the information in question, and also the stage in the review test and who is making the decision, for example, the Chief Constable, ministers, or the independent reviewer.
Do you accept, Minister, that there are some witnesses who, in fact, two specific witnesses who raised questions about how able they will be to make the interpretation about the different categories of information that you've just cited, because they are concerned that although there might be good guidance forthcoming, that this will come down, especially if it's challenged, this will come down to a legal interpretation, and they don't feel confident and competent to be able to make some of these judgments. Is that potentially a concern for you in terms of the progress of this bill?
It's obviously a concern if stakeholders are saying that they don't feel confident in the process. I think I'll ask my legal official to provide some information to try and clarify the situation for yourselves and for stakeholders.
Certainly, thank you, Minister. The two-part test, as the Minister has said, is well established and has been approved in multiple decisions of the Supreme Court, including the case referred to in the letter from the Faculty of Advocates, which is the case of L against Commissioner of Police of the Metropolis. And the leading judgment in that case was delivered by Lord Neuberger, who commented that if the test was only one of relevance to the purpose of the disclosure, then that would be insufficient to meet the proportionality test in terms of Article 8 of the ECHR. But because the Chief Officer has to then go on and consider whether the information ought to be included, that is the part of the test, that is a necessary part of the test for establishing the proportionality test. And he did give some examples of factors that would be considered as part of that decision of what ought to be included, and that would include things like the gravity of the material, the reliability of the information on which it was based, whether the applicant had a chance to dispute it, the relevance to a particular job application, the time period since the events had occurred, and also the impact on the applicant. And so compliance with those established principles now for any decision maker applying those tests is necessary to ensure that the decision is lawful and proportionate. And I think the Faculty of Advocates had also commented in their letter that they supported the Minister's comments in her previous letter to the committee that the test would be informed by case law from the courts and reflected in guidance. And I think it's also worth making the point that in preparing this bill, there's a balancing between the need for foreseeability, which we recognise is a key component of having a piece of legislation that is consistent with ECHR requirements, but also allowing for flexibility, which I think some of the witnesses have recognised as an important part of a rights-based approach. So having a nuanced approach, particularly in relation to childhood convictions, and I think that's been supported by a number of witnesses.
So could I just ask then, I mean, obviously Police Scotland, Disclosure Scotland, and any independent reviewer will be very cognizant of the law as it is in the two tests. Just to put it back into the framework for somebody who is running an organisation that has volunteers, I think some of them are concerned that the specialist information that they require to make a judgment about what is relevant information and what ought to be disclosed is actually quite a difficult one. And therefore, what I'm really asking, Minister, is in your engagement, you said you're going to have very extensive engagement with stakeholders. What will you do to ensure that within the guidance there will be an assurance given to all those who have to make a judgment about relevant information, what ought to be disclosed, that is very clear to those in the bodies who are looking after volunteers?
I think that's a very, very important consideration to log with, in terms of the bill moving forward. We have two strands really to ongoing which are going to help with that. The current police arrangements in England and Wales have a QAF, a quality assurance framework, which provides a decision-making framework precisely to help chief constables make decisions in line with that two-part test effectively. And we're going to, hopefully, as part of the bill as it moves forward, produce similar integrity of guidance for Scotland, which provides that framework and structure. But also at the same time, we've got another strand which is called Scotland Works for You, which is about engaging employers the length and breadth of the country to talk about how they use disclosure information more effectively to make balanced and proportionate decisions about allowing people back into work whenever they've had a previous conviction or a problem in the past, safely back into work. So we think there's a twin-track approach that's needed with the bill. There's obviously the decision-making process around how to put the information onto the disclosure fairly and accurately, and also this other piece which is about trying to equip and prime the pump for employers to use it better. And I think without that strand, then perhaps it would be more difficult to build that kind of knowledge base and strength of decision-making.
Can we have one more question? Just on that point, it's a very interesting one, and I'm not at liberty to disclose the name of the person who we saw in a private session, but it was raised as this person was an employer, and it was raised that the information that is given to the employer is different from the self-disclosure. And just in relation to what you've said, Mr. Hart, that potentially is a problem. And can I just ask how you would address that?
On the issue of synchronisation between self-disclosure and state disclosure, we recognise that the two have to match, and we are working on solutions particularly for the situation for children to make sure that the two do match.
You say how? What are you going to do to make sure that they tie up?
So the principle has to be, as the Minister's just said, that there has to be a predictability for the individual about what they have to disclose. And where there is no immediate, obvious, identical duty on the individual because of the operation of the rules in the always list as to what might be removed on appeal, there is a presumption the individual does not have to disclose those matters until those appeals are exhausted. So the duty on the individual to self-disclose crystallises at the point whenever the state decides what will be disclosed. And that is the principle that defaults to protect the rights of the individual rather than the other way where the duty somehow hangs over the individual until such times as the state makes a different decision. It's the opposite of that. So the individual should be able to, and we'll do a lot in stakeholder engagement and in also our online work to make it very clear, the calculator and the process about how this is worked out, and we've still to do that work with stakeholders, how to get that across most effectively. But the individual will be under no adverse position in terms of having to disclose things which they might not later have to disclose were they successful in an appeal against a conviction.
That's helpful. I just think there are issues about when an employer wants to take somebody on as a volunteer, that there is potential for some information to have been disclosed by the person who is the volunteer. I think that's quite an issue if I could just ask you to consider that in your engagement.
Yes, and we will. I think that is a possibility, but I think the stakeholder engagement piece that we have to do has to be around preparing employers to really interact with the bill and with the Act, hopefully as it will become in a positive and progressive way.
Mr. Johnson?
So, Minister, just following on from Liz Smith's line of questioning around the two tests, I was wondering if you could provide an example of information that would meet the relevance test but fail the ought test.
I'll have a step.
Be able to answer the question.
I think I'll ask my official to. You can see we're all looking at each other slightly.
In some ways, your response, I think, illustrates, I think, the difficulty we've been having. Because while I accept that it's a well-established test in the courts, I think the clarity that's required both for people applying those tests, whether it's looking at disclosure themselves, or indeed people who may be applying for these checks, that may be somewhat lacking. So I was wondering if you could comment on the fair degree of consensus been from witnesses that actually it would be a good idea to establish the principles that would be applied to that ought test on the face of the bill. I mean, in particular, the Law Society and indeed the Howard League, I think, gave some quite good examples of the sorts of principles that could be put on the face of the bill and indeed how they could maintain the flexibility. I was wondering if you could comment on that suggestion.
So an obvious example of something where there may be a question of whether it ought to be disclosed is a very early childhood conviction, say when somebody was aged 10, whether that is still ought to be disclosed later in life is certainly something that I would like to think that would be carefully considered. I think I'm going to ask Gemma to give you more detail on the legal specifics that you've asked for. This is a really complex area, and I want to be absolutely sure that we get on record the absolutely accurate situation and correct answers to your questions so that we can move forward and develop this legislation in the simplest way possible so that it serves the people it's meant to serve.
So this is an example, just to reiterate some of the factors that the Supreme Court has said would be pertinent to that decision of what ought to be included. It could be, in line with the example the Minister has given, the length of time that has elapsed since the conviction was accrued by an individual. So it may be that a conviction which on the face of it would be relevant to the role that a person was applying for, nevertheless ought not to be disclosed because it was so historic and there had been no pattern of offending behaviour in the interim period. That may then depend on the severity of the conviction itself, where even after a passage of time it may still be relevant and it ought to be disclosed. So that aspect of the test is what ensures proportionality of the interference with the rights of an individual. And I think it does, although the courts have recognised that in certain circumstances there should be bright line rules, this is one of those areas where it's difficult to have such bright line rules because it's inherent in the nature of this type of decision that allowing flexibility, in fact, supports the rights of individuals and may in some circumstances allow them to move on from past offending.
So I mean, my slight issue with that is in the very judgment that you cited, the judge actually provided a set of criteria. And indeed, the Howard League, in their evidence, suggested criteria such as the circumstances of the offence, the number of offences, the age at the time of the offence, which has been referenced, and indeed how recently those offences were committed. And that's very similar to what the judge in that Supreme Court judgment stated. So I'm just wondering why you wouldn't put those on the face of the bill, in particular if you actually made them amendable by either affirmative or negative procedures such as the Law Society have suggested. That seems to me that would provide both the clarity that I think would be welcomed and also the flexibility, which I think rightly you referenced as being important.
So certainly we're open to dialogue about whether the codification could improve the situation and improve the clarity. I think it's probably helpful if I put into context just there are bright lines around the vast majority of the decisions that are made. In terms of disclosure certificates, so I think it's useful to have in mind the number. Disclosure certificates containing conviction information accrued between the age of 12 and 17. Last year there were only 600 of them in the whole year. In 2018, 275,200 PVG certificates were issued. Only 401 of those contained ORI information, so that's 0.15% of the certificates during the period that contained ORI. So I think it's helpful to understand that there are bright lines and clear guidance around the vast majority of decisions made. It's just a very small number that are affected by this two-part test.
I think that depends on what your frame of reference is. I mean, 400 sounds like a lot of people. Can I just ask finally, I recognise that there have been these judgments at the Supreme Court, but I also note that those are judgments on English law and English cases. And while I understand that, of course, the courts up here will accept judgments at the Supreme Court as guiding their decisions, I'm just wondering whether or not that has an impact in terms of their legal status and indeed, therefore, the legal status of these two tests in this bill.
I don't think so, no. I don't think that would give me any concern at all. I mean, obviously the Supreme Court of the UK, we pay a great deal of attention to the judgments that are made in cases that are brought to there, whether they relate to Scottish cases or whether they relate to cases occurring in other parts of the UK. And
the judgments, if they're on English law, even if they're the Supreme Court.
That's correct. They're not
Yeah.
binding, but in this case they would be highly persuasive because
Yes.
the statutory test is in it precisely the same terms.
Thank you.
Dr. Allen?
Yeah, I'm just keen to come in briefly on the back of the example that the Minister gave there about how things would, how the system would work for an offence that was something that was committed when someone was 10 years old. Again, we've had a lot of anecdotal evidence as a committee, let me put it that way, about the problems that can be faced if somebody in that situation is in a children's hearing and accepts grounds, sometimes grounds or an offence that they don't quite understand without legal representation. Are you satisfied that the new system that we will have will deal more, if that's an adverb, understandingly with people in that situation?
so we understand that it's difficult for children to understand that offending behaviour and the acceptance of offence grounds can have lifelong consequences with regard to employment opportunities, for example. And that's why the Age of Criminal Responsibility Act, the Management Offenders Act and this bill have all sought to reduce the scope for such information to be disclosed. The ACR Act raised the age of criminal responsibility and provides that behaviour under the age of 12 can only be disclosed as ORI. The Management of Offenders Act provides that children's hearings disposals become spent immediately, meaning they'll never appear on the lowest and most common level of disclosure, the basic level or level 1 disclosure. And the bill ends the automatic disclosure of childhood convictions, replacing this with a case-by-case individual approach. I think that's a real improvement on the current situation, and I think the way the three bills and acts interact shows a really cohesive approach to this difficult issue that concerns all of us.
Thank you.
Ms Mackay?
Thank you, Convener. Good morning, Minister. I wanted to ask you about the list of offences and in particular the criteria used for the timescales for disclosure and the content of those lists. The Commissioner for Children and Young People is quoted in our evidence as saying, an approach based on lists of offences is a blunt instrument which does not allow for a proper assessment of risk of future harm. He raises and concerns also raised about whether there should be separate lists for childhood and adult offences. The Centre for Youth and Criminal Justice also raised a concern with us about, for instance, as an example, willful fire raising as a List A offence, and they relate this to the offences that can accrue to care experienced children in specific circumstances. So I wonder if you could set out what criteria was used for the content, how these lists have been split, and the timescale criteria for disclosure.
So we're aware that some of the respondents to the bill in the oral evidence in committee have suggested that there should be different lists for children, but having a different list, I think, would increase the complexity, and that's something that we want to avoid. All the lists do is act as a filter, so they remove from scope convictions that are irrelevant for state disclosure. And for those which are automatically non-disclosable as a result of that filtering process, the inclusion of childhood conviction information is subject to a case-by-case assessment of the information by ministers firstly, and then the independent reviewer if necessary. So we consider that tailored approach to be much more proportionate than introducing a separate list of convictions for of offences for childhood convictions.
And, you know, regarding the content, we have heard concern about the content of these lists, you know, possibly being out of proportion or not compatible. I mean, is that something that you would work on with other stakeholders to try and, you know, refine? Or
so we think, I mean, we're always willing to work closely with stakeholders, and I think you've heard in the evidence that's been given before now just how closely Disclosure Scotland do work with stakeholders. Much of the content of this bill is as a result of that close engagement and work together. There are really strong policy justifications for the two different lists. Without them, there would be no distinction between offences such as public indecency, which is a List B offence, and rape, which is a List A offence. Both of them are relevant and serious, and to justify the need to be able to disclose after they become spent. But having just one list would fail to acknowledge that we're dealing with a spectrum of offences. And that was a point acknowledged by the Law Society for Scotland during their evidence.
so with regard to childhood offences, and in particular care experienced children, etc., I mean, do you still have the view that they should be treated the same, or would there be any consideration given to the, you know, the external circumstances?
The lists are not an articulation of wishing to treat them the same, because there's a process behind the operation of the lists which will allow the unique and individual circumstances of each of the persons affected to be fully considered. We, as an organisation, we've been really cognisant of care experienced young people and the increased propensity they have to become convicted, you know, as children. It's a very serious problem, and we're fully in partnership with Who Cares Scotland and other organisations, including the CYCJ, around trying to really address this problem in a very real way. So what we would see is that the lists are actually probably better seen as a way to say what's not disclosable, which is the vast majority of stuff. You know, it isn't going to be disclosed because they're not on these lists. And then they kickstart a process whereby that nuanced and individual look is taken at the material so that a proper, fair and balanced decision can be made. There are some young people whose offending will indicate a serious propensity to go on to cause serious harm as adults, but the vast majority of young people, even young people who commit sexually harmful behaviour in childhood, do not go on to perpetrate that kind of behaviour in adulthood. So we have to have there's no way that we can have a process other than a completely nuanced and qualitative process to really sift through that information to try and make sure that we only attach the disclosure, you know, status to someone who really genuinely needs that persistently, and for the vast majority of young people to not have to face the kind of persistent disclosure of childhood problems.
Okay. I'm just concerned about the detail of the bill. Then will that be, you know, worded in such a way that it's made clear that it's not a sort of, you know, a black and white case? Or
the guidance that will be produced for our staff in the Scottish Government, for the independent reviewer and for the police, will all have at its very heart the balance that has to be struck between fairness to the individual and protection of the public. And I think that has to be fully cognisant of the really serious and evidence-based concerns that are around young people who are looked after and accommodated, and the kind of trajectory they can have in life because of the persistence of disclosure. So I think that will be absolutely central to writing good guidance, which will prepare with the stakeholders so that it's, you know, as kind of shared as possible in its both its conception and its operation, and made subject to constant review or regular review.
thank you. Just very, sorry.
Sorry, I was just going to add that in terms of the wording of the bill, a conviction that is non-disclosable because of the operation of the lists cannot be a childhood conviction, so that it's not then it's not disclosable at all. It doesn't go through the decision-making process. It's not subject to the statutory test. It just falls off the disclosure. So that is something that's a feature of the bill at the moment.
Okay, thanks. Just very briefly, with regard to the timescales that have been proposed, I mean, I'm just wondering what general criteria you use to make those.
Well, we could have. The bill doesn't set out timescales, and the reason for that was we wanted to engage with stakeholders to set appropriate timescales. We don't want to set something that doesn't give individuals enough time to engage in the process. But by the same token, we don't want to set timescales that give organisations who we might need information from too long, because obviously we want to make sure that process works as quickly as it's possible, because we are aware that delays could be seen, you know, as a proxy for something is going on there. And the approach that we're taking is that certainly that we think we can deliver these in terms of the numbers that are involved in a matter of, you know, days. We're not talking months, which it is just now for applications to get convictions removed from your disclosure by a sheriff can take months, if not over 12 months. So we're certainly seeing this approach as something that radically improves the situation for people who want to apply to have information removed from their disclosure.
Okay, so you're confident it will speed up?
Yes, absolutely.
Okay, thank you.
Okay, Ms Ross.
Good morning, panel. I just want to follow up on a quick point that Gemma, you made about childhood convictions automatically falling off. Does that mean that they are there but not disclosed, or does that mean that they're permanently deleted and there's no record of them ever having happened?
So if somebody had a conviction in childhood that had become non-disclosable because of the passage of time, then that would not be included in any of their disclosure products under the bill. As a matter of record keeping, I would need to check with my disclosure colleagues whether that information is still held.
Well, we disclose from the police record. So they have obviously they have a criminal history system and the police national computer and other systems that they maintain for the purpose of law enforcement and for the apprehension of offenders. So we disclose from that. So we post-process that information when we take it from them and apply the disclosure rules to that information. So the police would still hold the information, but they have their own weeding and retention rules, which are commonly referred to as 20, 40, 70 proportionality rules, and they apply them independently. It's the Chief Constable that applies those. The information that we process is drawn from their systems, and we process it post that. So the police would still know unless they weeded it, but it wouldn't be disclosed by the state on a disclosure.
Okay, thank you. To move on to something that I asked about before, and Gemma, it was also you that said it in some previous evidence about the Article 8 of the Human Rights Act, and we had Alison Reid from Clan Child Law who said the system as it's proposed in the bill is so complex as to mean there is a lack of foreseeability, and it's at risk of being incompatible with Article 8 of the ECHR, and also in the Faculty of Advocates evidence that we recently got, they also talk about the representation of an unwarranted invasion of an individual's Article 8 rights. I wonder if you could maybe just explain to us how you see that evidence. Is that a genuine concern?
I can certainly confirm that in order for laws to be compatible with the ECHR, they need to be foreseeable in their effects. And that means that they need to be accessible to the people who are affected by them. And it also means they need to not be arbitrary. So if a piece of legislation gives a decision maker discretion, then there has to be sufficient clarity about the way in which that discretion will be exercised. What the case law doesn't say is that decision makers and public bodies are not permitted to have such discretion in making decisions. It's just about having a set of parameters that are based on either guidance or already known and established legal principles, so that the application of those rules is reasonably foreseeable in practice. And the Scottish Government's position is that the existing legislation and what's set out in the bill is sufficiently foreseeable, and that will also be informed by the guidance that's to be developed in consultation with stakeholders.
Okay. Thank you for that. One of the things that she did say is that about the foreseeable aspect, and I'll quote her, "We are trying to explain the scheme to young people who potentially have complex mental health issues, who have experienced physical and emotional abuse or trauma, or who have been exposed to neglect. And they're trying to explain to them really complex concepts." So in that sense, I think she's possibly at odds at what you just said about it being foreseeable. So I asked her about what would make it simpler in her view. And she said the way that childhood offending behaviour is addressed, our view is that it simply should not be treated as a conviction. So do you have any opinions on that?
I think, I mean, discretion is absolutely vital to balance public protection and rights, and that's well established in the whole process of disclosure and state disclosure. I think I'll ask Gerard to give you more detail about how we intend to engage with stakeholders to make sure that they understand well and to make sure that there's material available to share with people about how decisions might be made and how that might impact on future prospects.
As the Minister just remarked, I mean, the concept behind the bill in this regard is to try and provide the right tools to make sure that the individual circumstances of anyone who's got a criminal record that could be disclosed can have access to fair and proportionate ways to have their case looked at on an individual level. Now, you could have two poles. You could have a system whereby everything is disclosed, which was kind of where we were before the UKSC ruling in 2014 and our subsequent convention compliance order in 2015. Or you could have a system whereby nothing was disclosed and everything was protected in that regard. And there are camps of opinion out there which would have you do both. What we're trying to do is strike the right balance between those two things, and I think that obviously and necessarily drives in a degree of discretion into the consideration process. And I think we've tried to solve that by some of the things that we've talked about today. The rules list give a very clear, and the always list as we call them, the 8A and the 8B as they currently are, give a very clear articulation of what is never disclosed and what could be disclosed, and the new appeal processes that are being put in place give a very ready access to justice for those people who want to have those things looked at. The imposition of the independent reviewer across the whole process adds a huge new layer of proportionality and fairness, but that does bring a degree of complexity because it's a complex problem, and we're trying to solve a complex problem that needs that individual nuanced approach. But to counter that, what we do have to do is write really great guidance that's fantastically clear for everybody to understand, to do that in partnership with all of our stakeholders, and to have really great online services that allow people to access those things really easily. And that we're really determined to do that and have that kind of openness and clarity in the process.
If I could just add, the government is confident that that this bill helps to deliver a system of disclosure of childhood convictions that's fairer and more individualised, and that it strikes a more proportionate balance between being able to move on from past behaviour and from wider public protection. One thing that we haven't highlighted so far in our evidence is that the bill provides for those with childhood convictions to provide representations, including the detail about the wider context of their previous behaviour, to ministers before any disclosure to a third party is made. And that's quite a significant change from the current system, and I think really improves the proportionality and the privacy for individuals who are needing to use the disclosure system.
Okay, thank you. Can I bring in Dr. Allen?
Thank you very much, Convener. Probably you've touched on some areas around this already, but not all of them. And it was interested in the question of context around convictions. Does the new legislation allow for context to be either disclosed where relevant, or perhaps you could say a bit more about how context forms or informs decisions to disclose?
So the decision-making frameworks where the two test is applied is where people would use the context and seek to get further information to help them make a decision over whether something needs to be disclosed or not. And as I said, there are three different situations where that applies with ORI, with ministers and disclosing information, and with the independent reviewer, that test applies. So that is where context will be sought so that people can make a good informed decision about whether something is relevant and whether it ought to be disclosed. And they will have access to suitable context for those decisions to be made.
And in terms of the role of ministers in the system, can you say a bit more about what that role is and whether you see that role increasing or decreasing, or whether you see that role as being an improvement on what's there just now? How much discretion or involvement are ministers likely to have at any stage in this process in any cases?
I guess in very simple terms, the ministers make the first decision. So they make the first decision on whether something needs to be disclosed or not. Disclosure Scotland, on behalf of Scottish ministers, make that first judgment. There is then a process of ensuring that the person about whom information is to be disclosed has an opportunity to see that, if they're a child, and then to make an appeal to the independent reviewer. I'll ask one of my colleagues to add some more detail on how the system works.
I understand that decisions will be made on behalf of ministers, but are there any circumstances in which decisions could end up on the minister's desk, is what I'm driving at?
It has happened that we have consulted ministers. The Caltrona principle, which applies across the civil service, means that when we make decisions, sorry Kevin, I've stolen your thunder there, it means that we make decisions, we make them on behalf of the minister, as if the minister had made them herself, and she's accountable for those decisions. So we obviously have to do that with full cognizance of what that might mean, and sometimes it's right to, where there's a particular, difficult matter, to let ministers see those cases, and we do that from time to time. In terms of context, though, what I would say is that sometimes it's right to disclose the context of something as well, in order for it to be understood by the person who's going to use the information. Running the barring service, the PVG barring service, I see from time to time cases where it's been a murder, say 30 years ago, and it just says murder, life imprisonment, and you don't know, because often the records are deleted, you don't know what the details are. But actually, in a sort of curious and really helpful way, what we're doing now with the disclosure of information, much more than just a bland conviction, allows for some of the context around behaviour to be set out, which is therefore accessible further on, down the line. So, for example, in circumstances where a very awful murder takes place, perhaps a rape and murder, and it's horrible circumstances, but that person may well find 30 years from now, if they were in the current situation, that what's disclosed is murder, Glasgow High, life. In 30 years' time, what might be disclosed is information about the context of that murder, which gives the person using the information a bit more information than they have just now, actually improving public protection and focusing in information better on the task for which it's been provided. So there are really thought through a context about providing context that we've considered as part of the bill.
Add that in terms of the provisions in the bill for providing context, representations will be at the heart of all of the review mechanisms. So individuals will have the opportunity to provide that context themselves. There are also wide information gathering powers for both ministers in exercising their functions under the bill, and for the independent reviewer to ask third parties to provide context-specific information.
Thank you. A completely, or not completely, but not directly related question, I suppose, is on the other side of the equation about education and awareness. When do you think that individuals will be able to have confidence in working out when they're actually required to self-declare information, say when they're applying for a job? Do you think that that's something that people will continue to be aware of, or will need education about?
I think that education will always be needed for that particular aspect around self-disclosure. As I said earlier, there is a principle that the self-disclosure should synchronise with the state disclosure, and we are certainly working to ensure that that is the case with this bill.
Thank you.
Mr. Gray.
We've touched on, a couple of times, we've touched on the interaction between the proposed bill and existing legislation. And in particular, the consistency or lack of consistency between self-disclosure and state disclosure regimes. There are probably, I think, 3 pieces of legislation which are relevant here. One's the Rehabilitation of Offenders Act 1974, the Age of Criminal Responsibility, recent legislation, and the Management of Offenders Act 2019, all of which do have perhaps some contradictions with what's proposed in the bill. And I know both this morning, but also in your letter, Minister, you've indicated that you do intend to bring forward amendments to the bill in order to try and resolve this. And I just wonder if you could give us a bit more detail of exactly what amendments and how you intend to resolve these contradictions.
So we're still considering that at the moment, so I can't give you detail today, but I can certainly promise to bring forward detail in as timely a manner as possible so that you have time as a committee to consider that detail before we reach stage 2.
I mean, that is quite pressing because, you know, this is the end of our consideration, stage 1 consideration of the bill. So can you say when you think you're going to be able to show us how you intend to amend the bill?
What I can say is right now the regime that's covered under Rehabilitation of Offenders Act for self-disclosure and then state disclosure, which is governed by the 1997 Act and PVG Act, are broadly aligned just now. And real issue is the treatment that we're taking in terms of childhood convictions, because what the bill says that there'll be a case-by-case assessment. So if we've done nothing to the Rehabilitation of Offenders Act as it applies just now, it would mean that Act compels a person to disclose a conviction from under the age of 18 while it is unspent, yet the bill proposes that the state will take a case-by-case approach to that. So you could have a situation where a person is required to disclose under ROA, but then the state disclosure, it doesn't disclose it. So the bill provisions, therefore, are of no use to that person in that circumstance. So that's the issue that we need to fix. It is, you know, it's a complicated area, you know, in terms of the Rehabilitation of Offenders Act is not our policy area, but it also has necessary connections in terms of what we're doing under this bill, and work is ongoing with our justice colleagues to try and resolve this issue and bring forward amendments and make the committee aware as early as we can about those.
So the obvious question is, or the obvious way of fixing this inconsistency would be to amend the Rehabilitation of Offenders Act. Are you saying you don't know if that's what you'll be able to do?
That is our intention, to make consequential amendments to the Rehabilitation of Offenders Act.
But you implied there you were still in discussion as to whether you could do that.
In terms of the how, not
the principle.
Yeah.
Okay.
Jerry,
Well, just to add that we're working to the principle that the systems should be aligned, and where they fail on the side of fairness to the individual. When I say fail, I mean when there's any ambiguity whatsoever, that needs to be on that side. So we've got a number of policy models as to how this can be solved, and ministers are considering those. And we would hope to be able to, you know, the minister will indicate how quickly she intends to bring this forward. But we are advanced in terms of our thinking around how this is taken forward.
So in your letter, Minister, you said that this bill didn't amend the Age of Criminal Responsibility Act or the Management of Offenders Act because at that point neither of those had received royal assent, so they weren't in the statute book. So are you intending to bring forward amendments to this bill which will amend those 2 pieces of legislation?
Do you want to?
There are a number of consequential amendments required to the Age of Criminal Responsibility Act because the disclosure mechanisms that were introduced for under 12 behaviour were based on the Police Act still being in force. So there will be some updating required to that piece of legislation as well.
So when will you be able to tell us what those are?
As soon as we possibly can.
That's not much of an answer.
Well, so the Management of Offenders Bill only came through this year. It's the 2019 Act, and when I wrote to you, these things were not yet enacted. These are very recent pieces of legislation. I think that what you're seeing here is a government who are taking a very cohesive approach across 3 pieces of legislation to try to solve some of these really challenging issues that have taxed and vexed all of us for many years. So I am working actively on all of these issues. I will bring them forward absolutely as timely as I can. I want you to be able to scrutinise what we're doing. I want you to be able to understand what we're doing, but necessarily I can't do that. I couldn't do it before they were enacted.
So before the committee enters into stage 2 of the bill proceedings?
I'm keen to make sure that you have all of the information you need before you enter stage 2, yes.
I think being probably requires more than being keen, but thanks very much.
Mr Greer.
Thank you, Convener. Minister, I'd like to turn to the issue of the minimum age and how under-16s relate to the scheme. You mentioned in your opening remarks the situation in England, Wales and Northern Ireland where under-16s not having to take part in equivalent schemes doesn't seem to impact their ability to participate. I'm not familiar with the schemes in the rest of the UK. Was that as a result of similar changes to the ones proposed here? Because the concern that has been raised is around the impact that a change would make in the system in relation to participation. If that has simply always been the case in the rest of the UK, it's not particularly comparable.
Yeah, it was a change they made more recently, so it is similar to the situation here. I think we are very keen not to discourage volunteering amongst children and young people. They volunteer more than adults do, and they contribute a huge amount to Scotland by doing that, and we want to make sure that it's still possible for them to do that. I think you heard some evidence from some organisations who already consider children to be different when they're volunteers, who already would not require them to have PVGs, who already would not require them to perform roles which we would consider to be regulated work, to take on that responsibility. I think I don't really have a concern that in Scotland there are, I'm confident that we will still be able to provide plenty of opportunities for children to volunteer. And I don't think the change will be as significant as we imagine, because it's already happened all over the rest of the UK without great consequence.
I agree absolutely that there are organisations who submitted evidence around the fact that they distinguish between those under 16 and over 16. That's best practice, and we can't make law on the basis of assuming that everyone will follow best practice. So there are concerns around this. It would be useful, just before we move on to a couple more specific questions, if you could just clarify. The concern here is that the combination of the offence in relation to undertaking a regulated role without appropriate disclosure and the movement to an under-16 system, that would create a system, that would create an impression where particularly smaller organisations that are primarily volunteer-led, who've got less infrastructure, would feel that in effect meant the safest position for them to take was to not have under-16s participate in that kind of work. Now, I accept that that is not the intention. The concern is that that would be an effect. But just to clarify from your perspective, what is the problem that is being solved by setting 16 as minimum age? Is this an issue of proportionality?
I think it's an issue of privacy, really, for children under 16, that they don't need to have these things disclosed. They shouldn't, that it's not necessary for them to have these things disclosed. I think what you're articulating here, again, is a challenge to us to ensure that we have really good engagement with stakeholders and really good materials produced to ensure that absolutely everybody who is using the disclosure system in Scotland is very clear about how it operates and what their responsibilities are. And we are very, very aware that we need to do a good job on that, and we're certainly intending to do that. And I hope that I've mentioned before that many of the people giving evidence at committee previously have talked about the level of engagement with Disclosure Scotland. We are very keen to continue to engage intensively with everyone that we need to make sure that the system works at the end of the day. I'll ask you to give a little bit more about this.
I think there's a number of kind of underpinning things that we've been exploring with stakeholders in this matter. I think the first thing is that we're not saying children under age 16 can't get a disclosure. It's about joining the PVG scheme. The PVG scheme is about a persistent monitoring of you every single day, and the potential for, if something comes onto your scheme record, of you being considered for listing and barred. Now, any kid who's in a situation where their behaviour might be causing that level of concern ought to be getting managed under the Getting It Right for Every Child framework, in terms of all the different, aspects around police, social work, health, whoever, who might surround education, who might surround that child. So there's an expectation that those systems should be managing a risk and threat for children who might be at risk of having the kinds of behaviours at the extreme that PVG is there to try and stop. That said, though, the bill does make provision for children who cannot join the PVG scheme to still get what would effectively now be an enhanced disclosure. So it would still be possible to get a check done. But that might be only necessary in a very small number of cases because of the protections that I've just referred to. The idea being that that children ought not to be subjected to that kind of state scrutiny in normal circumstances, unless there's a really, really good reason, and even then it's as an enhanced disclosure rather than as a level 2 lower disclosure than as a PVG disclosure. Yes, when they turn 16 or 17, they're starting to work, and be part of the workforce properly. If that's the case, then yes, it's appropriate to join the PVG if it's a regulated role, but not before. I think that stakeholders have told us that again and again in different contexts, that they don't want children under the age of 16 to be drawn into this web of state disclosure and through PVG.
Yeah, I think what you've just touched on there very much relates to the concerns that have come up, that essentially underpinned by the idea that PVG is seen as the be-all and end-all, and it's seen particularly by smaller organisations who are less familiar with the detail of this as being the only product on offer. Just to clarify, so I understand how the system would work in relation to the small number of young people who are listed, but there's a larger group of young people whose behaviour may come up. If they were over 16, their behaviour may be disclosed, but they've not reached the threshold for listing. My understanding of what's proposed here is that would essentially be managed through the GARFIC process. The concern there is that's not perfect. We would all acknowledge that, particularly when young people move between local authorities, situations that are dependent on local authorities' social work services in particular, that can create a lot of pressure, and sometimes people do fall through the cracks. But from what you've just said, Mr. Hart, are those the kind of situations where enhanced disclosure should be the appropriate product that is used?
Yeah. It's everyone's job to make sure that children and protected adults are safe, and that means that the system has to join up across all its different aspects. So disclosure is not the panacea for reducing all and limiting all risk. We saw that in the youth football abuse matters, that there has to be a real coming together of different parties to make safeguarding work. Disclosure is part of that, but it's not all of it. So we can eliminate risk by having, a really joined up systems. GARFIC aims to do that. That's the whole point of the government's policy around joining up children's services and having that kind of focus on the child. So we would anticipate that the kind of behaviours, the sexually harmful behaviours that we're talking about, it's my experience as a former social worker and a former social work inspector with SPIA, that there are really good services across Scotland dealing with these kinds of behaviours and joining up information exchange, for example, and passing on child protection messaging, etc., between different places. So we would anticipate that the collective goodness of the system would be sufficient to deal with the risks here, rather than having to try and crack a nut with a walnut with a sledgehammer.
Thank you.
Thank you, Ms. Goldruth.
Good morning to the panel. I'd like to address some of the concerns that have been raised by Scottish Women's Aid in their submission, and they're quite technical. They relate to Section 76. So you might be aware that SWA have argued there's a need to redefine the meaning of protected adult, because this is currently listed in terms of vulnerability through disability or illness, and they say that focusing on these two areas has created a loophole, as the definition won't automatically cover women experiencing domestic abuse. And I just wonder if the government's given any consideration to this.
So the Scottish Government's experience of operating the PVG schemes highlighted challenges with the current definition. The policy intention was to move away from the current lengthy and complex definition to focus on the range of issues affecting a person's well-being, capabilities and capacity, which mean that they require additional safeguarding protections. I agree with the stakeholder comments that simplification and clarity of process must not be to the detriment of the protection of vulnerable groups, and efforts to make the definition easier to navigate for users have to be balanced with safeguarding. We're listening very carefully to stakeholders, and we will certainly consider how to move forward in light of their views.
Thank you for that, Minister. Also within their submission, they say that it limits the protection to adults regarded as being vulnerable due to a personal condition, and this is defined as a mental or physical disability, illness or old age. And they go on to say that this is really a specific issue for women experiencing domestic abuse who might be accessing refuge accommodation, for example. They're asking for the government to rewrite this part of the legislation specifically to include the full spectrum of services within which regulated roles in respect of protected adults would exist. And I appreciate, Minister, I think in response to Ian Gray, you said you're not quite there yet in terms of being able to give us the detail, but is this something with regard to the amendments which the government might bring forward that the government are actively looking at specifically with regard to women?
So certainly I acknowledge that there's a question on whether the definition of protected adults appropriately scoped, and my officials have met with Scottish Women's Aid to discuss their concerns about the new definition, and we're reflecting on the gaps, on any gaps that have been created by it, and we'll certainly consider an approach to amendments. As you say, I can't tell you right now exactly what we'll do at stage 2, but we're certainly considering an approach.
Thank you.
Okay, Ms Wishart?
I think actually the issues I was going to raise have been covered in previous comments. So it was about the children's hearings and long-term consequences. I think we've covered that. Thank you.
Thank you, Ms Harris.
Most of my issues have been covered. Thank you.
Okay, Minister, if I could just ask a couple of questions before we finish, and thank you for your letter to the committee laying out the further consultation around fees, which was very helpful. But it's been raised slightly today, and do you think that the changes in this bill will ensure that organisations do not rely too heavily on the PVG scheme as a sort of be-all and end-all of decision making?
Certainly, I mean, you've heard from numerous stakeholders giving evidence, and I would certainly reiterate my concern that there is sometimes a perception that the PVG scheme is the catch-all, and as long as you're PVG checked, you're safe. And I think that everyone in this room would be concerned about perpetuating that myth. So we want to be, you know, in my role as Minister for Children and Young People, I want to be absolutely clear that there is more to safeguarding than simply PVG checking, and that safeguarding children is absolutely everyone's responsibility.
And I know you are consulting on fees, but can you explain how volunteers who move to paid work will be charged under the PVG scheme when currently volunteers are, can apply, or organisations can apply for a fee?
So I'll ask you to
yes, the idea is, the policy idea is that people should be able to really take ownership of their PVG scheme membership and use it in a way which actually benefits their career and which helps the economy function even better. And that applies both in the paid work sector and in the volunteering sector. There's a Rubicon between paid and volunteer work, and when someone crosses that Rubicon, we will need to decide how that fee structure will apply. That will be something that we take forward in the consultation on fees. And if we have any proposals to make about how that is done, it will be done with stakeholder engagement and user research around how to elegantly make that Rubicon something that can be crossed with ease. A lot of that will be about digital and online and about making things easy to access, but the detail of that is still to be developed, because we'll do that with our stakeholders.
Okay. And what information, so obviously if somebody's in a volunteering role and then becomes paid in an organisation, how will you ensure that the organisation and the person themselves understand that they're moving into, a failure to receive a PVG as undertaking regulatory work, which will then become an offence? How do we ensure that that will be dealt with proportionately when there is an area of concern there?
Certainly, to answer this, the position would be that the individual, whenever they want to work for any organisation, the safeguarding payload of the scheme is in us knowing that they're working for that organisation. And as part of the registration of that transaction, for us to know that this person wants to work for organisation A, the status of that work will have to be disclosed to us, because if it's unpaid, there's no fee. If it's not unpaid, if it's voluntary, there's no fee, or if it's paid work, there will be a fee. So that transaction, which is necessary for us to register the organisation and to deal with the transaction of giving the disclosure, will also, as a byproduct, allow us to identify when the transaction is one that should be paid for or should be free.
Okay, Ms Smith, you wanted to...
Matter of clarification, Minister, one witness raised an issue that is a potential anomaly, given that there is usually one person within an organisation who's responsible for looking after disclosure information and passing it on to the relevant authorities. If there is a complaint about that one person, would you be able to clarify what would happen in that instance? As in, a complaint is made about that person in terms of the PVG, yet they are also responsible for looking after the information in the...
Yeah, do you want to?
So in circumstances where the counter-signatory becomes themselves the subject of a consideration for barring, for example, the Scottish Government, Disclosure Scotland, will write out under Section 30 of the current legislation to the employer of that person and state, that the person's under consideration for barring. Now, very rarely, not entirely unheard of, but very rarely is the individual who coordinates the disclosure process the very top individual, or even close to the top of the organisation. So we would be notifying their superior in the organisation that they were now under this status. So that would allow them to take any relevant action to safeguard.
Legislation will cover
well,
that.
The current legislation covers that, actually, because we will first of all.
I'm just asking, does the new legislation
yes, that
cover
continues. That? Yes, that continues in the future also, and as it currently exists. And we also, for these people who are logged with us to be counter-signatories, we vet them as part of the disclosure process. So they have to go through separate checks, and they're quite rigorous checks to make sure they're a suitable person to receive disclosure information. So that's also done, which is an extra safeguard.
Thank you.
Okay, I think that concludes questions from the committee. Can I thank the Minister and her officials for attendance this morning. That concludes the session today. Next week we take evidence from the Cabinet Secretary for Education and Skills on the progress on the recommendations from the committee's report on Scottish National Standardised Assessment, subject choices and on the exam diet in 2019. And we now move into private session.